The first case to come before us this morning is State of Ohio versus Stephen A. Snowberger. Both sides will have 15 minutes to argue. If you are the appellant and wish to reserve some time for rebuttal, you can reserve up to 5 minutes for rebuttal. And if you let me know when you get started, I'm keeping track of the clock this morning. Please don't use the names of any victims or minors as we are live streaming this oral argument. We've read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. Sorry, is my audio coming through clearly?
Yes, it is.
Thank you. Good morning, Your Honors. May it please the court and opposing counsel. Attorney Jacob Will on behalf of the appellant Stephen Snowberger. Your Honors, I would like to initially note that I'm going to rest on my briefs with respect to errors of argument, assignments of error 1 and 3. I wanted to briefly discuss assignment of error 2 this morning while we have a few minutes together. As you are all aware, on February 14th of 2020, Mr. Snowberger was stopped by the Cuyahoga Falls Police Department, and he was essentially stopped in a gas station parking lot and then ultimately arrested for an OVI by the arresting officer. It's mentioned in the brief. It was subject to a lot of litigation at trial. There was a suppression hearing, but ultimately the assignment of error we're arguing today, Your Honors, is that the trial court erred in denying the motion to suppress. And I'd like to focus specifically today on the probable cause inquiry. As this court is well aware, in State v. Spies, a 9th District case, an officer has probable cause to arrest an individual for impaired driving if, at the time of arrest, the officer had sufficient facts derived from a reasonably trustworthy source to cause a prudent person to believe the suspect was driving under the influence. The case goes on to say this inquiry requires consideration of the totality of circumstances known to the officer at the time of the arrest. And I put that last part in there because I think it's important in this case. Officer Barbie of the Cuyahoga Falls Police Department indicated at trial and at the suppression hearing that he had made the decision to arrest Mr. Snowberger for an OVI before he ever offered any field sobriety tests. That's not completely unusual or out of the norm in an OVI prosecution, of course, but in this particular case, I think it bears repeating because the only factors that were relied upon and utilized by Officer Barbie were the red eyes, slurred speech, and the odor of alcohol. So there were 3 factors that were utilized based on his own testimony at both the suppression and at trial for why he arrested Mr. Snowberger. I know the state makes some mention in their brief about how granting an assignment of error in this capacity would render prosecution of OVIs impossible. I don't think I agree with that statement. There certainly can be many other situations where there'd be other factors prior to the admission of field sobriety tests that could lead to viable probable cause. I just don't believe it exists in this case. I cited 2 cases in the brief. I'd like to just briefly discuss them. One is State v. Finch, and while I can appreciate, of course, that's a 12th District case, I know that that's only persuasive to this court. I raised it in the brief because it was subsequently used by the 9th District in State v. Hop. And ultimately, in both of those cases, the courts made determinations that there was not probable cause to arrest based on the number of factors that are present in this case. In Hop, for example, there was an admission to drinking, thick tongue speech, odor of alcohol, bloodshot eyes. I think I can make a compelling argument that there was more factors for probable cause in State v. Hop, a case in which the 9th District found there was not sufficient probable cause to arrest for an OVI. I raised that. I know that was brought up by the state in their brief as well, but I think that even the distinction factually that Hop involved an OVI checkpoint as opposed to observing a traffic violation or an alleged traffic violation, there still is not enough in this case with Mr. Snowberger as far as the officer's observations to permit a finding by the trial court of probable cause.
Excuse me, counsel, yes. But did the officer also factor in the speeding and the rolled stop sign in addition to the red eyes, the slurred speech and odor of alcohol, and making that probable cause finding? And wouldn't that distinguish it from the Hop case where it was just a stop at a checkpoint as opposed to the officer observing moving violations? Go ahead.
Yes, Your Honor. Thank you. I would indicate that is the factual distinction between this case and Hop. What I would suggest is that Officer Barbie at trial at the suppression indicated that he did not attribute the alleged stop sign violation as a factor of impairment because, quote, everybody rolls a stop sign. I think an easy way to distinguish this from other cases where we observe bad driving is what type of alleged bad driving are we seeing? There are plenty of cases that can be found where weaving, crossing the double yellow center line, going over the white fog line, weaving in your own lane even could be sufficient to corroborate probable cause with these other factors that are present. But in this particular case, this rolled stop sign was specifically stated by the officer. It was not a factor in his probable cause determination. And so I think that that's an important way to distinguish many other cases that we might see as both practitioners and as the court, where there is actual erratic driving. I don't know that I would characterize this as erratic driving, and I don't believe that in the record the officer characterized it as erratic driving. It appears as though the sole sort of basis for it.
You
Counsel,
muted, counsel.
The brief time between out of the vehicle and then sees the red eye.
You're muted again. Counsel, you're muted again. Mr. Will, you are muted again.
Sorry, was it losing?
You are breaking up a little bit. Your screen image has broke up, and we did not hear probably the last minute of your argument.
I'm sorry. Did you guys lose me?
We did.
I apologize.
It's okay.
I'm sorry, but my personal argument by Zoom. My apologies. I think I was saying though that in this particular case, it was just a 6-minute window of interaction before the officer decided to make the decision to arrest. So, for those reasons, for the reasons that I've stated in my brief, Your Honors, I would respectfully contend that the trial court erred in denying the motion to suppress, and along with assignments of error 1 and 3, we would ask that the matter be vacated and reversed back for further proceedings. Thank you.
Counsel,
if there's no further questions.
Could I ask you a question?
Yes, Your Honor.
You mentioned that with the rolling stop sign that the officer had not considered that in his probable cause determination. Does that really matter if, in fact, there was probable cause? In other words, we've said it's not so much a subjective officer, but what a reasonable officer would find. So if we review all the evidence, just like the trial judge did, and there is evidence that we consider to be sufficient for probable cause, does it really matter what the officer thought? I'm trying to figure this out.
Right. Thank you, Your Honor. I think that the way I would respond to that is when you're looking at a fact-specific case and you're looking at, each individual decision of probable cause, it is important, I think, to what the objective reasonable officer would think, but I don't think there's anything to suggest that Officer Barbie wasn't acting as the objective reasonable officer who was using all the information available to him. When pressed upon the issue of the stop sign, and then when the trial court and the jury watched the video, he was ultimately acquitted of that stop sign charge. And so I guess from where we're standing, it was not utilized in the probable cause determination. I don't know that it would be sufficient to show erratic driving the way that we normally see that distinguished, as I mentioned previously, from weaving or coming in and out of lanes or even weaving inside of a lane. So I don't believe that the facts here provide enough erratic driving evidence to support probable cause with the minimal factors that were present other than those driving issues.
Thank you, counsel.
Thank you, Your Honor.
Counsel for the state.
Thank you, Your Honor. May it please the court. We would also stand on our brief as far as the other assignments of error. As far as the denial of the motion to suppress, I think it's important if you look at what Officer Barb did testify to on that. He was asked if the stop sign in and of itself is a sign of impairment, and the officer was honest. No, people who are not impaired may also roll a stop sign. However, it does not take away that is reasonable suspicion of criminal activity to stop the vehicle, and then also it can be a factor in the probable cause determination. Defense counsel or appellate counsel also is not mentioned in the fact that he was also observed and paced going twice the legal speed limit in a 25 zone, which was also taken into account by the officer as reasonable suspicion of criminal activity. And then once he got the vehicle stopped based on both of those traffic violations, which the law gives him the right to pull him over based on those violations, then he smelled the odor of alcohol. Then he saw the red glossy bloodshot eyes, and he heard the slurred speech. All of those things taken together under the totality of the circumstances known to the officer at the time, that's what gives him the probable cause to arrest him. The case law that we cited is specific, saying you do not need field sobriety tests. You do not need an admission of guilt, because if those are the case, that is what would render law enforcement unable to enforce the OVI laws, as it would be a minimum requirement, and all the person has to do is deny it to the officer and they'd have to let him go. In this case, the totality of circumstances is the traffic violations, along with the other factors that the officer testified to and that his training said are indicators of impairment. And we feel that in the light most favorable to the prosecution at the time, and based on competent, credible evidence of the officer, would give more than enough probable cause to arrest the defendant for driving under the influence. We feel the minimal constitutional requirements were met in that.
So Hop is distinguished because of the fact that it was a roadblock.
A checkpoint, yes, Your Honor.
A
We would
checkpoint.
say that because in Hop, the whole reason that they were even having an interaction with him was the OVI checkpoint. In this case, it was not a checkpoint. There were traffic violations that show impairment. Rolling a stop sign can be a sign of impairment, and speeding can be a sign of impairment. That is what would separate it from the case counsel has referred to in this case. They also talk about an unaided visual estimate, which we say is not unaided because the officer testified about his speedometer as well, which the speed and the stop sign being traffic violations would give him enough to pull him over, leading then to the indicia of alcohol impairment or alcohol consumption.
The officer indicated, according to Attorney Will, that the speed and the stop sign were not indicative of impairment, to him at least. Would you agree there was no erratic driving other than, well, there was no erratic driving that he observed? So when we look at the totality of the circumstances, how does that all factor in? I mean, he indicates that it's not indicative. Those two things aren't indicative of impairment, and there was no other impaired or erratic driving observed. You know, I'm just trying to see what you think as to an analysis of totality of the circumstances, given that testimony and the fact there was no erratic driving.
Well, Your Honor, I believe that, and I could be wrong because it's been a while since we had had the motion to suppress, but I believe the officer said that stop sign in and of itself is not an indicator of impairment, and that speeding in and of itself is not an indicator of impairment. I would say that is erratic driving. That's why we have laws against it. Rolling a stop sign is erratic driving. Speeding is erratic driving. Whether or not, as the officer, again, he was trying to be honest, and I think he was, said that a lot of people do speed and people do roll stop signs. It doesn't make it legal, and it doesn't take away from the steps that have to come into play. And that got his attention. That's what drew his attention to the vehicle. When he pulled him over based on that, then the rest of the indicia of the odor, the eyes, and the speech would all come into play in determining that there was, in fact, probable cause.
Thank you.
Thank you.
Thank you, counsel. Counsel for the appellant, you have 5 minutes for rebuttal.
I have nothing additional to add, Your Honor. I would just rest on the remainder of the briefs and the arguments that I presented. Thank you.
Counsel, the only thing I'm sorry. Counsel,
sorry.
the only thing I would ask you is, I can't remember, and I was trying to catch it real quick here. I know the officer was just getting ready to end his shift. What time was it again?
The time of the actual stop, it would have been, I think, close to 10 p.m. It was dark out. I don't have the exact time right in front of me, Your Honor. I apologize, but it was towards
That's
the
all
end of the shift. I believe it was around 10 o'clock. I'm sure counsel for the state can tell me if I'm incorrect.
I think it was at least 10 o'clock, Your Honor. The officer was on a special detail, so it wasn't a normal end of shift time for the.
That's what I was
calls.
wondering, because I'm like, that's not a normal shift thing.
No, he was
Okay.
on an extra detail.
Okay, thank you. Thank you, gentlemen.
Thank you.
Thank you.
Thank you both for your presentations today. The court will take a matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Our next video oral argument is this Thursday, August 26th. Thank you, everyone. We're adjourned. Have a great day.
Thank
Thanks,
you, Your
Your Honors.
Honor.
Take care.
Take
Thank
care.
you.